If your paycheck hits your bank account through direct deposit, 3 rules that changed recently are quietly deciding how much of that money you actually get to keep right now. Most people never notice any of this is happening. By the end of this video, you'll know all 3, including the last one, which almost nobody believes could possibly apply to them. They're wrong. I'm no licensed expert, but on this channel every week I cover the real financial information that affects you directly, the rules that change, the protections you already qualify for, and the steps that actually make a difference. This is exactly the kind of content I put out every single week, and you don't want to miss it. If that's the kind of information you're looking for, go ahead and hit subscribe and turn on notifications right now. Now let's get into it. Direct deposit was designed to be simple. Your employer or the federal government sends the money electronically. It lands in your account and you spend it. That was the arrangement for decades, and nobody thought twice about it. But 2 developments changed the picture. First, fintech apps like Chime, Dave, and Cash App started advertising early access to your paycheck, sometimes up to 2 days before it officially posted. That marketing push exposed something a lot of traditional banks would rather have kept quiet. Banks were sitting on direct deposits for 1 to 5 business days, sometimes longer, without giving account holders any real notice. People found out the hard way, usually through an overdraft fee on money they were certain had already cleared. Second, direct deposit fraud spiked. Criminals began going after HR portals and payroll systems directly, changing an employee's routing and account number on file and rerouting entire paychecks into accounts the employee never opened or even knew existed. That combination, hidden holes and rising fraud, pushed regulators to update 3 separate pieces of the direct deposit process. They came from different agencies, took effect on different timelines, and none of them were rolled out in a way an ordinary account holder would ever stumble across. That's really the whole problem. Nobody tells you these protections exist unless you happen to be sitting across from someone whose job it is to explain them to you. Before we get into the details, here's the quick version for 2 different situations. If you're living paycheck to paycheck, these rules matter the most to you because one unexplained hold can snowball into overdraft charges, return payments, and a banking relationship that takes months to repair. All 3 rules include specific protections built for exactly that scenario. And if you're in a more comfortable position financially, don't tune out. The offset rule has no income floor, and a payroll fraud gap can drain a large balance account just as easily as a small one. Rule 1 is the new hold time disclosure requirement. The Expedited Funds Availability Act has required banks to make direct deposit funds available within set time frames for years now. The enforcement gap was that banks were leaning on exceptions written into the law to justify extended holds, and doing it without giving people adequate written notice. Under Regulation CC, which governs how quickly deposited funds have to become available, a bank placing a hold longer than the standard next business day window is required to give written notice. Not a verbal explanation from a teller, but something in writing that states the reason for the hold and the date your money will actually be available. Updated enforcement guidance has put real weight behind that requirement. Banks that hold electronic payroll deposits without providing that written notice can now face examination findings and civil penalties from the CFPB. And here's the part that matters most directly to you. If your bank held your deposit without proper written notice and you racked up overdraft fees during that hold, you have grounds to ask for those fees back. Nobody mails you a form for this. Automatically, you have to know to ask. The assumption that costs people the most money is believing the bank can hold funds however long it wants. No questions asked. That's simply not accurate, and Regulation CC under Title 12 of the Code of Federal Regulations spells out exactly when a bank has to notify you. Picture Patricia, 58, a licensed practical nurse in Columbus, Ohio, whose paycheck lands every other Friday. One spring, her bank placed a 3-business-day hold, citing a new account exception. Even though she'd banked there 11 years, no written notice arrived. 3 scheduled bill payments bounced that weekend, triggering 3 separate overdraft fees plus return payment fees from 2 payees. Patricia ended up out $172 for money that was already legally hers. If your income is tight, the protection here is direct. Any hold applied without written notice is a violation you can challenge in writing to recover those fees. If your finances are more comfortable, your exposure is smaller but not gone. Large, unusual direct deposits, a year-end bonus, a lump sum government payment can still trigger extended holds, and the same notice requirement still applies to those. It's also worth knowing that Regulation CC separates reasonable cause holds from standard holds, and a reasonable cause hold has to be tied to something specific about your account, not a blanket policy the bank slaps on every new customer. If your bank cites reasonable cause and can't tell you what that reason actually is when you ask, that's worth reporting to the CFPB. The step to take here is simple. Contact your bank in writing, not by phone, and ask for a copy of your account's current hold policy for direct deposits. Ask specifically what the standard availability window is for your account type under Regulation CC, and which exceptions the bank is authorized to use. Keep that answer on file. It becomes your baseline if a future hold produces fees you want to dispute. Rule 2 is the Payroll Verification and Routing Accountability Update. The fraud pattern mentioned earlier got serious enough that Nacha, the organization governing the ACH network that handles almost every direct deposit in the country, updated its rules to place more accountability on payroll processors and their clients. The change requires financial institutions and processors to validate an account before a deposit is ever sent, confirming the routing and account number actually belong to the intended recipient before the funds leave. In practice, that means 2 things for you. Employers and payroll processors are now more accountable when fraud slips through an unvalidated routing change. And every ACH direct deposit now carries a trace number, a unique identifier that lets that transaction be tracked from start to finish through the processing chain. That trace number is available to you on request under the updated rules, and almost nobody ever asks for it. HR departments rarely bring it up. Payroll companies don't advertise it, but it exists for every paycheck that's ever landed in your account by direct deposit, and is the single most useful tool for resolving a misdirected or stolen paycheck quickly. The mistake that drags recovery out for weeks is calling HR first when a paycheck goes missing. HR calls the payroll processor. The processor opens an internal ticket and time slips away. A faster path is contacting HR and your bank's ACH dispute department, at the same time giving them the expected deposit amount, settlement date, and a request to trace that specific transaction. With a trace number, your bank can go directly to the receiving institution through the ACH return process. Without it, that process slows down and sometimes stalls entirely. This helps 2 groups differently. If money is tight, a misdirected paycheck isn't an inconvenience. It's a crisis, and the trace number protocol shortens that recovery window instead of leaving you at the mercy of your employer's internal process. If you're more comfortable financially, your bigger risk is fraud, since larger balance accounts tend to get targeted more often. The new validation rule adds front-end protection, but knowing the trace number exists and how to use it is what gives you real leverage if something goes wrong. Take a second right now and pull up your most recent direct deposit, not last month's statement. The transaction sitting in your account today. Note the settlement date and exact amount. Those are what you'll give HR or payroll when you request the ACH trace number for that deposit. It should take no more than about a day for your employer to retrieve it. If they can't, that's worth flagging to your bank. If your employer runs payroll through ADP, Paychecks, or Gusto, trace lookup is usually built right into the employee portal. Nacha has also expanded same-day ACH processing, which works in your favor. More processors can now settle deposits the same day instead of the next, shrinking the window a bank has to justify any hold. So here's what I want you to do. The benefits, the discounts, the assistance programs most seniors qualify for but never actually use, I gathered them all in one spot, organized by state and by program, so you don't have to dig through confusing government websites for hours. It's quick, it's straightforward, and any senior can find exactly what fits their situation. No matter what state you're in, there's help out there you're probably leaving on the table. It's called the Senior Exempts Playbook, and it's sitting in the first pinned comment right under this video. Just tap it once and you'll have everything you need. Now stay right here, because the last one is where the federal government itself steps into your account. The rule that lets money be pulled straight out of a direct deposit before you ever see it, and almost nobody realizes how far it actually reaches. Rule 3 is the government offset expansion under the Treasury offset program. The program is run by the Bureau of the Fiscal Service, which sits inside the U.S. Department of the Treasury, and it exists to collect delinquent debts by intercepting federal payments before or as they land. Even before this expansion, it already captured tax refunds, Social Security payments, federal employee wages, and federal contractor payments to satisfy qualifying debts. Things like defaulted federal student loans, unpaid federal taxes, and state income tax debts referred in through participating states. What's changed is the scope of debts that qualify and how fast the offset happens once one is referred. More states are now participating, and more categories of state-level debt, municipal court fines, benefit overpayments, past due child support are flowing into the federal program, even in states that weren't active before. Once a debt is referred, the offset is automatic. No court order, no lawsuit. The money is intercepted before it reaches your account, or the moment it arrives, depending on the payment type. Every Social Security recipient should know this number. Under 31 U.S.C. Section 3716, benefits subject to offset are protected up to a floor of $750 a month. Anything above that is fair game once a qualifying debt is referred. Someone receiving $1,400 a month has $650 exposed. That $750 floor is fixed in the statute. It hasn't adjusted for inflation in years, so it protects less every year prices climb. For people receiving paychecks from a federal employer, the math works differently, following the same disposable income formula used in standard wage garnishment. 15% per pay period, or the amount pay exceeds 30 times the federal minimum wage, whichever is smaller. Tax refunds run through this same system with no floor protection at all. A qualifying debt can absorb an entire refund in one pass, with notice arriving afterward. What catches people off guard is that debts referred years ago can sit in the system indefinitely. A student loan someone believed was resolved, a state tax balance someone thought was settled. Any of it can trigger an offset with no fresh warning. Consider Gerald, 67, a retired postal worker in Memphis, Tennessee, who receives a federal pension and Social Security by direct deposit. 3 years earlier, he'd set up an informal repayment plan with his state's Department of Revenue on a tax balance and believed it was cleared after 8 months of payments. It wasn't. The state had referred the balance to the federal offset program before he ever started paying, and the referral was never withdrawn. His next pension deposit came in $412 short, with the only notice being a letter that arrived 2 days after the offset had already happened. If you're a Social Security recipient on a tight budget, the $750 floor exists specifically to protect you. And knowing it exists means you can push back on any offset that drops your payment below that line. If you receive federal pay or a federal pension and you're more financially comfortable, your exposure scales with your income, since the 15% calculation takes a bigger dollar amount out of a bigger paycheck. The mistake that makes an offset worse is calling the wrong agency first. When people notice an unexpected shortfall, the instinct is to call whoever they think the debt belongs to. But the offset itself is executed by the Bureau of the Fiscal Service, not the original creditor agency, so that call almost never stops anything. Only a formal dispute or referral withdrawal submitted through the Bureau of the Fiscal Service actually halts an active offset. Here's what to do about it, and none of it requires a lawyer. First, call the Treasury Offset Program call center at 800-304-3107 and provide your Social Security number. The automated system will tell you whether a debt has been referred and which agency referred it. Do this before your next expected deposit, not after. Second, know that under 31 U.S.C. Section 3716, the referring agency is required to send a pre-offset notice explaining the debt amount and your right to dispute it before any referral happens. If you were offset without ever receiving that notice, request written proof it was sent. Third, if the debt is wrong or already resolved, file a dispute with the referring agency and ask them to confirm in writing that they've submitted a referral withdrawal to the Bureau of the Fiscal Service. Fourth, if you receive Social Security and your payment dropped below $750 a month, contact the Social Security Administration at 800-772-1213 and cite the 31 U.S.C. Section 3716, protected floor by name. There's one more federal protection worth knowing, separate from the offset program itself. Under a Treasury rule at 31 CFR Part 212, banks are required to review 2 months of account history before honoring a private creditor's garnishment order, and automatically shield a set amount tied to federal benefits like Social Security, Virginia payments, and certain federal retirement benefits from that garnishment. This applies to private debt collectors going through the courts, not federal agencies collecting federal debt. But it means those protected benefits can't be swept entirely by a private judgment creditor, even with a court order involved. Most people never learn it applies to them until they actually need it. It's also worth opening a second account at a different institution to receive your direct deposit separate from your everyday spending account. That doesn't eliminate offset exposure for federal payments, but it creates practical separation that can limit the reach of a bank-initiated hold or a garnishment action while a dispute is in progress. Several states also exempt a portion of direct deposit funds in accounts specifically designated for payroll or benefits from private creditor garnishment. So it's worth checking your own state's rules on top of the federal ones. And turn on real-time deposit alerts in your banking app if you haven't already. Set it to notify you the moment a deposit posts and the moment any hold or reduction is applied. Most banks offer this for free, and almost nobody turns it on. Without it, a short deposit can go unnoticed for days while you're left trying to piece together what happened after the fact, instead of catching it same day. The thread running through all 3 rules is the same. Your bank, your payroll processor, and the federal offset program are each operating under specific legal obligations toward you. Your bank has to notify you of extended holds in writing. Your payroll processor has to give you a trace number when you ask. The Bureau of the Fiscal Service has to confirm the referring agency sent notice before an offset happens. None of these obligations enforce themselves. Everyone depends on you knowing to ask, to document, and sometimes to push back in writing. Nobody hands you a pamphlet about any of this when you open an account. That's the difference between Patricia paying $172 she never owed and Patricia keeping it. That's the difference between Gerald losing $412 with no warning and Gerald catching the referral before it ever touches his next payment. One last thing worth knowing. Closing an account and opening a new one elsewhere doesn't make any of this disappear. Hold policies are often tied to how new a relationship is with a specific bank. So closing and reopening can trigger a fresh new account hold exception instead of avoiding one. And offsets are tied to your Social Security number and the debt itself, not to any bank or account number. So moving your money doesn't take you out of the Bureau of the Fiscal Services database. The only thing that actually resolves any of this is working the dispute process directly, using the specific citations and contact points we just went through. You now have all three rules and exactly what to do about each one.